Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this content, please remember to subscribe. It helps the channel grow. For today's case, we're dealing with access to public information and some of the people who might not want you to have it. This is the Uniform Fire Officers Association and Police versus the City of New York. In this case, New York changed its law on public information, the FOIA law, although it's called something different in New York. It's called FOIL, the same thing. Anyway, they changed the law to allow disciplinary records to be accessed by the public. And the police and firefighters associations are not thrilled. They'd like you not to have access to their records. So we're going to analyze whether or not the public can get access to the disciplinary records of cops and firefighters. Let's get started with this. This appeal arises from the repeal of Section 50A of the New York Civil Rights Law, which for decades shielded law enforcement disciplinary records from public disclosure. Shortly after the repeal, New York City announced its intention to proactively publish certain kinds of disciplinary records and to provide other records upon request for its obligations under New York's Freedom of Information Law, which is FOIA, but they call it FOIL because I don't know, but it's in the New York Code. So yeah, you can get access to these records now, and the police aren't happy about it. The unions moved to preliminarily enjoin any disclosure of allegations of misconduct against their members. They're unsubstantiated, unfounded, non-final, or resulted in exoneration. Each of the union's collective bargaining agreements contains an arbitration provision, and the unions asked the court to enjoin the New York Police Department and the other planned disclosures pending adjudication of their claims in arbitration. So they say, we'd like this to be arbitrated, whether or not this can be done. All right, so can we go to arbitration? Because we have a contract that says, let's go to arbitration. All right. Under New York law, which governs the collective bargaining association agreements, a court may issue a preliminary injunction in aid of arbitration if the movement demonstrates that, absent a preliminary injunction, an award in arbitration may be rendered ineffectual. The movement is likely to succeed on the merits of the claim to be arbitrated. There's danger of irreparable harm, and the balance of equities tips in the favor. If this sounds familiar to you, then that's because it's the same four-part standard worded slightly differently for every preliminary injunction. It's the same four-part standard for preliminary injunctions. It's worded slightly differently, but we've seen this time and time again. So can we issue a preliminary injunction? Okay. Here, the unions assert that planned disclosures will violate two provisions and comments to all of their collective bargaining. The district court denied the union's motion for a preliminary injunction only as it related to the first provision, which states that upon an officer's written request to the chief of personnel, the police department will remove from the personnel folder investigative reports which, upon completion of the investigation, are classified exonerated or unfounded. So the district court denied the injunction that would allow them to do this. Why? Removal of records from a personnel file, as called for by the arbitration agreement, does not require eliminating them from all of the city records. There is no contention that the city has failed to adhere to its obligation to remove the records from personnel files, or has improperly considered them in connection with personnel decisions, such as promotion or termination. Moreover, to the extent that this claim implicates that records must be disclosed under the FOIA law, the New York Public Police Department cannot bargain away its disclosure obligations. So I like this. I like this very, very much, and goes to show how precision in language can come to burn you when you're thinking about these things. So the collective bargaining agreement says the police officers can ask for certain information to be removed from the personnel file, and the court says that's great, but from your personnel file, not all the city records. So, screwed up the language on that one, I guess. And also the fact that they have failed to remove them from your personnel files is super interesting and all. But yeah. And also, even if this was meant to prevent disclosure to the public, you can't contract away certain obligations because contract is a matter of state law, right? The state has the power to determine what are and are not valid contracts, and they can change their mind. That which was legal can become illegal, and illegal provisions in a contract are void, as we've discussed many times. So this might have been legal at one point in time. New York changed its mind. New York said, you know what, we're not going to allow for this anymore. We want disclosure. And they say, that's not fair. We contracted for that. And New York says, well, that's fun and all, but unfortunately that provision is now illegal. So we're not going to give it any effect. Also, it doesn't mean that we have to delete them from all the records. So, sucks to be you just all the way around. The union asserts that law enforcement officers will have fewer employment opportunities in the future if records of allegations against them that prove to be unfounded or unsubstantiated are disclosed. We might not be able to get jobs from the disciplinary records, even though each record would reveal the outcome of the investigation. But the district court noted that future employers are likely to be misled by conduct records that contain a dispositional designation, specifying the allegations of misconduct were unsubstantiated, unfounded, or the accused officer was exonerated. So this won't hurt you in your employment opportunities because your future employers will see that you were acquitted. So what is your problem? As the district court noted, despite evidence that numerous other states make these records available to the public, the unions have pointed to no evidence from any jurisdiction. The availability of these records have resulted in harm from employment opportunities. For these reasons, the district court did not abuse discretion when it determined the asserted harm was speculative, and the unions had failed to demonstrate on the record the officers will suffer an irreparable harm to their employment opportunities that cannot be remedied by an award of lost wages. So the fact that people might not hire you in the future, well, you can't prove that, and we don't care. So, no. The unions have also not raised sufficiently serious questions on the merits of the claim. First, the unions assert a stigma plus claim under federal and New York state constitutions. Under both federal and state law, stigma plus requires the plaintiff to adequately demonstrate an injury to one's reputation, which is the stigma, coupled with deprivation of some tangible interest or property right, the plus, without adequate process. The unions fail to demonstrate that any officer will be deprived of tangible interest or property right. We've held that diminished future employment opportunities resulting from a damaged reputation, as opposed to some other independent legal detriment, are not sufficient. So even if you did have harm of getting a job in the future, that's a job in the future, not a job now. And you don't have a right to that job in the future now, do you? No. The union's equal protection claim fares no better. This should be entertaining. Because law enforcement officers are not a protected class for equal protection purposes, no. They must show that there is no rational and non-discriminating basis to treat their records differently from other public employees. Is there any reason to treat police department records differently from other public employees? Can we think of any? Even the unions recognize the unique responsibilities of law enforcement officers set them apart. Because the public has a stronger legitimate interest in the records of law enforcement than those of other public employees, the district court correctly determined that there was a rational, non-discriminatory reason for treating the two sets of records differently. Yeah, you're not a protected class, so that's going right out the window. And we might want your records and not other records because of the nature of your job. This is the old problem of who will watch the watchman. Well, as it turns out, one of the answers to that is the public at large, which is probably a really good answer to that question. So, deal with that. Besides, if you've done nothing wrong, you have nothing to hide. Am I right? The unions also argue that the city's decision to publish certain records without individualized review is arbitrary and capricious. As the district court observed, the city appears to recognize specific disclosure exemptions that are designed to protect against unwarranted invasions of privacy or endangering personal safety. We have considered the union's remaining arguments and conclude that they are without merit. For the foregoing reasons, the district court order is affirmed. Thus, that brings us to the end of the case of firefighters and police officers versus the city of New York. In this case, New York changed its law on public records that said that the records which were formerly not public are now public, the disciplinary records. And the unions say, that's not fair, we don't want disclosed. And the state of New York tells them to get bent. Yeah, it's real interesting and all that you have contracts about that, but those contracts are now illegal in part, so, sucks. Also, there's a reason that people want to see them because of what you do for a living. So, yeah, and future employment is not a property interest, and it's all speculative. So, no, you don't get any of that. The records can be public, at least for the moment. That brings us to the end of the discussion of this case.